All right, strap in, everybody. Let's take a deep dive into this world of legal strategy, in the tech world.
Yeah.
You shared this dissertation with us. Legal Leverage in New Technology Industry. Development of Strategic Framework by Aditya Kochhar.
Mm-hmm.
And it's basically like a playbook for companies, right?
Yeah.
Using the law not just to protect what they make, but how to, gain a competitive advantage.
It is. It's like a chess game, right?
Yeah.
Instead of rooks and pawns, we have patents and lawsuits and industry standards.
Oh, much more fun.
Yeah, a little bit higher stakes.
Way higher.
But yeah, Kochhar's framework is, he's actually inspired by the business model Canvas.
Oh, interesting.
And I think it does a really good job at kind of breaking down, these legal strategies into manageable chunks.
Okay, so let's break down this framework. So the first one we have is IP generation. Now, I know IP stands for intellectual property. But before we even get into the nitty-gritty like patents and trademarks and all that, help me understand, why should a company even bother with IP in the first place?
Yeah, that's the fundamental question. And the answer, I think, like many things in business, is it depends, right?
Sure.
So for a company like Apple, a giant company like Apple, a robust IP portfolio is all about protecting market share.
Mm-hmm.
So you think of these patents as weapons they can use to either block competitors or slow them down with lawsuits.
So it's almost like building a fortress around their existing products and technology.
Exactly, yeah. For a scrappy startup, though, the motivation's often very different.
Okay.
They may not have a huge market share to protect, but they're desperate to attract investors.
Sure.
And Kochhar points out that having a solid IP strategy can be a huge selling point for startups that are looking for funding.
Because it signals that they have something unique, something defensible.
Yeah.
Something worth betting on.
Precisely. It's about survival and growth. And it's convincing these investors that they have a fighting chance, in the marketplace.
Okay, so IP can be offensive or defensive, right?
Right.
Depending on the company's goals. But Kochhar mentions this idea of a smokescreen strategy.
Yeah.
What's that all about?
That's where it gets really interesting.
Okay.
So imagine a company patents not just their core technology, but all the variations around it, even some that might not be commercially viable.
Mm.
It's about creating this fog, making it much harder for competitors to see what they're up to.
Oh, sneaky.
Yeah.
I imagine all this IP strategizing, though, it comes at a cost.
Yeah.
Right.
You are absolutely right. Patenting's not for the faint of heart.
Right.
There's filing fees, there's renewal fees, and then there's the potential legal cost if you have to defend these patents in court.
So you need to weigh those costs and benefits.
Yeah. And Kochhar reminds us that the strength of a country's IP laws plays a huge role, too.
Oh, of course, yeah.
Yeah. A startup in the U.S. where IP rights are well protected might feel much more confident investing in patents than, say, a startup in a country where IP enforcement is much weaker.
That makes sense. It's the landscape, right? It shapes the game.
Yeah.
What about just the industry itself, though?
Yeah.
Does that affect how companies view IP strategy?
Hugely. Think about the pharmaceutical industry.
Mm-hmm.
Notoriously cutthroat when it comes to patents, right?
Yeah.
These drug companies, they invest billions of dollars in research and development.
Yeah.
And they rely heavily on patents to recoup those investments and protect their blockbuster drugs.
So it's constant court battles.
Yeah, they're constantly battling it out in court. Yeah.
Wow.
So if you're a pharma startup, you need to be prepared for a legal fight.
Intense. So even before you file a single patent application,
Yeah.
there's a lot to think about.
There is. And Kochhar challenges this assumption that patenting is always the best way to protect your innovation.
Mm.
He introduces this concept of alternative appropriability regimes, which is basically other ways to secure that competitive advantage.
Okay, now I'm intrigued.
Yeah.
What are these alternative regimes?
Sometimes the best strategy is secrecy, right?
Okay.
Think about the Coca-Cola formula.
Yeah.
They've never patented it. They've relied on trade secret laws to protect that recipe for over a century.
Makes sense. You don't want to give your competitors the recipe for your most valuable asset.
Right.
Are there other situations where secrecy is better than patenting?
Definitely. If your invention involves a complex manufacturing process that's difficult to reverse engineer even with a patent, maybe secrecy is the best bet.
Okay.
Or if you're operating in a country with weak IP protection, patenting might not be worth the hassle.
Interesting.
So you're assessing the risks and rewards of different approaches.
Yeah.
There's this thing called lead time, which is all about speed and agility.
Yeah.
In fast-moving industries like consumer electronics, being first to market is often the priority.
Yeah.
They may not even have time to secure patents, or they might decide that the competitive advantage outweighs the benefits of having a patent.
So it's like a race to capture market share before anyone else can catch up.
Exactly. And then there's this kind of counterintuitive strategy called public disclosure.
Wait, why would you ever share your invention with the world?
It seems risky,
It does.
but there are situations where it actually makes sense.
Okay.
Sometimes, by publicly disclosing your invention, you can attract collaborators, build a community around your technology, or even establish a de facto industry standard. Think of open source software,
Right.
where the code is freely available.
Yeah.
So you're creating that network effect,
Right.
where the more people who use your technology, the more valuable it becomes.
Right. So it's not an either or.
Right.
It's about what combination works best.
Most companies don't rely on just one of these strategies. It's a mix and match. It's combining patents and secrecy and lead time and even public disclosure to create a much more layered approach.
So it's choosing the right tool for the job, right?
Yeah.
Could you give me an example of how this might play out in the real world?
Sure. Think about a pharmaceutical company developing a new drug. They might file patents to protect the chemical compound itself, the specific methods for manufacturing it.
Okay.
But at the same time, they might publish scientific papers about their research findings.
Wait, wouldn't that be giving away their secrets?
It might seem that way,
Yeah.
but it's actually a strategic move.
Okay.
Because by publicly disclosing some aspects of their research, they're increasing the credibility of that patented drug.
Oh, okay.
They're demonstrating the scientific rigor behind it.
So they're using public disclosure to strengthen their patent.
Exactly.
Okay, that's clever. So we've talked about how companies protect their, tech babies
Yeah.
with IP, but how do they turn those IP assets into money? That's where commercialization comes in.
Exactly. It's about transforming these intangible assets, right,
Oh.
into profitable products and services. And the first step is to understand what makes an invention truly valuable.
Is it just having a patent?
A patent is part of it,
Okay.
but it's not the whole story. Kochhar really emphasizes this idea that it's the combination of the knowledge embodied in the patent, the team behind the invention, the supporting assets, whether it's manufacturing capabilities or marketing expertise.
It's the whole ecosystem.
Precisely.
Oh,
And the value of a patent can fluctuate throughout its life.
okay.
So, for example, if your patent's challenged in court and you successfully defend it, that actually increases its perceived value.
Because it's showing it's strong.
Exactly, it's enforceable.
Yeah.
On the flip side, if your patent is invalidated in court, its value plummets to zero.
Well, yeah, that makes sense. High stakes.
Yeah.
He also mentions how patents can be used for competitive intelligence.
Yes.
What does that mean?
So think of it this way. By analyzing your competitors' patents, you can gain valuable insight into their R&D focus, their technological strengths and weaknesses, and you can even anticipate their future moves.
Oh, interesting.
It's not about stealing ideas, it's about understanding that competitive landscape
Oh, okay.
to make informed decisions.
So it's like playing chess.
Yeah.
Trying to anticipate your opponent's next move.
Exactly.
Okay, now, when we think about startups, right?
Yeah.
Often they have these brilliant ideas,
Right.
but they don't have the money, they don't have the expertise, the resources to make those ideas into something.
Right.
What can they do?
Well, they're not alone. Kochhar outlines a few avenues.
Okay.
So government grants can be a lifeline, especially for early stage R&D.
Yeah.
Then there are angel investors and venture capitalists who are always looking for the next big thing.
Right. And those investors bring their own expertise to the table, too.
Absolutely. They've seen it all.
Yeah.
And their guidance can be invaluable.
Yeah.
Kochhar also highlights the rise of these specialized funds called patent-based investment funds, PBIFs.
PBIFs.
Yeah.
Tell me more about those.
They're basically venture capitalists obsessed with patents.
Okay.
They see the potential in these IP-driven businesses that might be overlooked by those traditional investors.
Interesting. So the funding is out there, but again, with all this IP stuff, there's always context, right?
Yes.
You can make or break it.
Yeah, the legal and regulatory landscape is huge.
Yeah.
Kochhar Contrast the US with its strong focus on IP rights with, say, the EU, which prioritizes competition law.
Oh, okay.
So in the US, it's relatively easy to enforce patents.
Yeah.
So licensing becomes a more attractive option for startups
Okay.
because they can confidently kind of rent out their technology knowing that their IP is protected.
So they don't have to manufacture and sell stuff themselves.
Right, it's a revenue stream. But in the EU, where competition is paramount, it might be easier for a startup to just enter the market directly,
Right.
even if it means going head-to-head with much bigger companies.
So the rules of the game change depending on where you play.
They do.
What else?
The type of innovation matters too.
Okay.
So if you have what's called a discrete invention, like a new chemical compound, it's much easier to license that than, say, a complex invention, like a new electronic device.
Okay, so it's like you can neatly package the IP.
Right.
Give it to somebody.
But with these complex inventions, there might be multiple patents involved,
Yeah.
owned by different companies.
Right.
So you see a lot more cross-licensing agreements,
Yeah.
where companies are basically swapping IP rights.
So you don't get bogged down in lawsuits.
Exactly.
Well, it's like a tangled web
It is.
of interconnected technology and agreements and all that.
And speaking of webs, Kochhar warns us about the dangers of what are called technology cartels.
Cartels. That sounds ominous.
They can be. These are groups of companies that collude to control a particular tech area, often by pooling their patents together to create barriers to entry for anybody else.
So it's like an exclusive club then
It is.
that can stifle competition.
Yeah, and startups need to be aware of these cartels
Okay.
and how they might impact their strategies.
Okay, so we talked about the value of IP, right?
Uh-huh.
And the challenges, right,
Yeah.
of commercializing it. But how do companies actually take that and make it profitable?
Right.
What are their choices?
Kochhar outlines 4 main value capture strategies: production and sale, outsourcing, licensing, and then the specialized engineering firm model.
Okay, let's break it down. So the first one, production and sale.
Yeah.
Seems straightforward.
Yeah.
You make the product, you sell it.
Classic.
What's so complicated about that?
It's the classic model, but it's also incredibly capital intensive,
Yeah.
especially for startups, right? You need to build or lease those manufacturing facilities, hire production staff. You've got to set up your distribution channels.
That's a lot to manage.
It's a lot.
So what about outsourcing then? Is that a way to kind of get rid of some of those headaches?
It can be.
Okay.
So outsourcing means handing off certain aspects, whether it's manufacturing or even marketing, to other companies that specialize in those areas.
So you can focus on your strengths.
Exactly.
Bring in experts where you need them.
Right.
Makes sense. What about licensing? We talked about that a little before.
Yeah.
So licensing is popular, especially for those companies that don't have the resources to manufacture and sell products themselves. It's like renting out your technology to others.
Yeah.
The licensee will pay a fee in the form of royalties
Okay.
for the right to use that patented technology.
Sounds simple.
It sounds simple.
I imagine the agreements can be pretty complicated, though.
They can be. There's a lot of details.
Yeah.
Things like royalty rates, scope of the license, how disputes are resolved.
Yeah. Lots to hammer out.
We'll get into some more of that later.
Okay. Looking forward to that.
Yeah.
What is this specialized engineering firm model?
So this is an intriguing model for these tech-focused startups.
Okay.
SEs, as they're called. They specialize in developing these process technologies and then licensing those out to others.
So they're like the masterminds behind the scenes then,
Exactly.
helping these other companies improve their manufacturing process.
Right. They might develop a new way to manufacture a particular material or a more efficient way to assemble a product,
Okay.
and then they license that out.
So it's like you're the architect,
Yeah,
but you let somebody else handle actually making it.
that's a great analogy.
Okay.
And Kochhar points out that they've had a huge impact on certain industries, like refining petrochemicals,
Okay.
where that process innovation is really critical.
So how does that work for a startup, though?
So it can be a great path for tech-focused startups, especially if they're strong on innovation, but they don't have the means to scale up manufacturing.
So they can stick to what they do best, the technology development,
Exactly.
and let the CEF handle all the messy manufacturing stuff.
Yeah, exactly.
Yeah.
Now, one last aspect of licensing I want to mention before we move on.
Okay.
Royalty rates.
We were discussing how, the strength of a patent can affect that.
Yeah.
What else is there?
Industry standards are a big factor as well.
Okay.
In certain industries, there are these established royalty rate ranges for specific types of technology.
So it's like a market price.
Yeah, a market price.
Mm-hmm.
And companies will often negotiate those royalty rates based on these industry benchmarks.
Okay.
But it's always a negotiation.
Yeah.
So there's room for flexibility.
What else? What else could affect it?
Well, the level of differentiation the licensed technology brings to a product can have a huge impact.
Right. So the more valuable your technology is,
Right.
the more they're willing to pay.
Right. Exactly. Supply and demand. And of course, the relative bargaining power of the two parties matters a lot.
Sure.
So it's like any other business negotiation.
Yeah.
You have to know what you're worth.
Yeah.
Be prepared to walk away if you're not getting a fair deal.
Okay. So we've covered licensing pretty in depth.
We have.
Let's go back to the litigation stuff. Earlier we talked about, those patent lawsuit risks, but Kochhar breaks down some specific tactics that companies use to navigate those battles.
Yeah.
So what can companies do to kind of stay out of that courtroom?
Well, one tactic, which we've touched on, is avoiding patent classes that are known to be populated by really aggressive competitors.
Right. If they're litigious, stay out of their way.
Exactly. Don't poke the bear.
Yeah.
Another tactic is to design your technology in a more modular way,
Okay.
with
Sure.
elements that can be easily swapped out if they're infringing on someone else's patent.
Right. We talked about that, the legal escape hatch.
Exactly. So if a
Yeah.
company discovers that, oh, this one component is infringing, they can quickly replace it without having to redesign the whole product.
Yeah.
And then we talked about open source standards, right?
Yeah.
That can significantly reduce litigation risk.
Right. Because you're using stuff that's freely available.
Exactly. And lastly, fostering a culture of cross-licensing and using those FRAND terms that we talked about,
Yeah.
that can create a more collaborative environment and
Yeah.
actually reduce the likelihood of lawsuits in the first place.
So we can all just get along
Hopefully.
in this IP world.
Fingers crossed.
Now, Kochhar also dedicates a whole section to dealing with non-practicing entities.
Yeah.
Those NPEs, specifically patent trolls, they sound like a headache and a half.
They can be.
So how can companies protect themselves from these trolls?
Vigilance is key.
Okay.
So companies need to be actively monitoring that patent landscape,
Mm-hmm.
identifying those potential troll threats early on.
So be on the lookout.
Exactly. Second, they can acquire strategically important patents themselves, specifically to block trolls from getting a hold of them.
Oh, I see. So you're disarming them
Exactly.
before they can attack.
And finally, you remember those defensive patent pools we talked about?
Yeah.
Those can be a powerful tool against trolls as well.
So you form a legal posse.
Yeah, exactly.
Companies band together.
Yeah, there's strength in numbers.
Right? Okay, so we've covered a lot on litigation, right?
You have.
From, why they even happened to those patent trolls.
Yeah.
But let's go back to this technical standards development.
Yeah.
We've talked about the different types of standards and the factors companies need to consider.
Right.
But I want to hear more about the specific strategies they use when it comes to actually shaping those standards.
So Kochhar outlines two main approaches:
Mm-hmm.
competing for de facto standards and participating in the more formal de jure standardization processes.
Right, we talked about that briefly.
Yeah.
But let's go back to that, more in depth.
So a de facto standard is one that emerges just through market dominance, not through any formal process.
Okay.
So think about the QWERTY keyboard layout.
Yeah.
It's the standard, not because some official body declared it to be so,
Right.
but because everyone uses it.
Right, so it's the standard because it is.
Exactly.
Yeah.
So those companies often focus on building a strong market position and creating that network effect.
Mm-hmm.
And it makes it really difficult for competitors to gain any traction.
So you're winning the popularity contest then.
Yeah, exactly.
What about the de jure?
So de jure standards are those established through formal processes, often involving these standards bodies, consortiums, even government agencies.
So everybody coming together to define the rules, basically.
Exactly. And companies participate in those to ensure interoperability,
Okay.
broader acceptance for their technologies,
Mm-hmm.
and to reduce that risk of legal challenges.
So they're working within the system.
Exactly.
Trying to shake things up.
Right.
So is it better to go for the de facto or the de jure?
It's a strategic decision.
Yeah.
Really depends on the company's size, resources, the competitive landscape, strategic goals.
No one right answer.
No one right answer, no.
But he gives some examples of companies that have done well with these.
He does, yeah.
I love a good example.
We talked about Microsoft Windows.
Yeah.
They're that classic case of a company that achieved de facto dominance.
Yeah.
their operating system became so ubiquitous.
Right. Everybody uses it.
It was very difficult to challenge them.
So it's like choosing between a sprint and a marathon.
That's a great analogy.
Yeah.
But he does point out that participating in those formal processes can be just as effective,
Yeah.
especially for companies that are looking to influence that long-term direction of an industry.
Okay.
So it depends on the situation and the desired outcome.
Sure. One thing we keep coming back to, though, these technical standards, they can have a big impact on innovation,
Yeah,
right?
huge.
So how can they influence innovation?
So on the positive side, standards can actually create a level playing field that fosters competition and encourages innovation.
Okay.
So when everybody's working from the same basic building blocks, it frees up companies to focus on developing new and improved products.
So it's like a shared language, right?
Exactly.
Everybody can use.
But then there's the flip side.
Okay.
Standards can also stifle innovation
Right.
if they become too rigid,
Yeah.
or if they're controlled by a small group of companies that resist change.
It's a balancing act.
It is.
Yay.
It's about finding that right balance between standardization and flexibility.
So it sounds like companies really need to think about how standards might affect innovation.
Absolutely.
And, try to advocate for standards that promote that balance.
Right, yeah.
Okay, so we've covered a lot today.
We have.
From the basics of IP all the way to technical standards.
Mhm.
But before we wrap up, there's something that's been bugging me this whole time.
Okay, what's that?
We've talked a lot about how companies use, the law and legal strategy to protect what they make
Yeah.
and to gain a competitive edge.
Right.
What about the ethics of all this?
That's a great question. It's definitely something to think about.
We've seen, companies use patents to stifle competition,
Yeah.
filing these frivolous lawsuits,
Yeah.
bullying rivals,
Right?
even messing with technical standards to, lock out competitors.
Yeah, it can definitely be harmful to
Right.
consumers and the innovation ecosystem as a whole.
So how do we find that balance then? How do companies protect their stuff but not do all that?
That's the million-dollar question.
Yeah.
No easy answer. But I think it starts with recognizing that IP law isn't just a set of rules.
Mm-hmm.
It's really a framework
Yeah.
for balancing these different, competing interests.
Okay. Go on.
So the goal is to encourage innovation.
Right.
Right. But those rights, they have to be weighed against the public's interest in being able to access new technologies.
Right. Benefiting from competition.
Exactly.
Yeah.
So it's a very delicate ecosystem.
Right.
It requires careful stewardship.
So it's everybody's job, right,
Right.
to make sure it's ethical.
Companies, policymakers, even consumers need to ensure that IP laws applied responsibly.
Okay, so we've done a lot in this deep dive.
We have.
All about, using law in the tech world.
We have. And honestly, we've only scratched the surface.
Yeah.
This is a fascinating, complex,
Oh, yeah.
and constantly evolving area.
But hopefully, at least now, our listeners will have a better understanding
Yeah.
of how companies use these legal strategies, to protect their work, to compete,
Yeah.
and to shape the future of tech.
That's the goal.
And we also touched on those ethical implications,
Mhm.
which are only going to become more important as technology keeps developing.
Absolutely.
So I'd like to leave everyone with this thought.
Okay.
Technology is evolving so fast.
Yeah.
What role should law play in all of this? In encouraging this innovation, but also making sure it's fair, it's ethical, and there's a balance, right,
Mhm.
between competition and collaboration.
Yeah. I mean, it's a huge question.
It is.
And one that we're all going to have to grapple with, right?
Yeah.
As we move into this uncharted territory.
Yeah. But before we get too lost in the big picture, are there any other insights, from his framework that we haven't touched on?
There are a few. One that I think is especially relevant in today's, globalized tech industry is this idea of jurisdiction shopping.
Jurisdiction shopping. That sounds a little sneaky.
It can be.
Okay.
It refers to this practice of strategically choosing where to file a lawsuit,
Okay.
based on things like the strength of a jurisdiction's IP laws, the likelihood of getting a favorable ruling, even the speed and cost of legal proceedings.
So you're kind of playing the legal system.
Exactly. To your advantage.
And it's especially relevant in tech, right?
Yeah.
Where companies often have operations and IP rights in multiple countries.
Right. So they might choose to sue in a country where they think they'll win,
Yeah.
even if the infringement didn't even happen there.
Right. It's about maximizing your chances of success, minimizing risk. But it is controversial.
Yeah, I bet.
It can be seen as form shopping or even an abuse of the system.
Right.
And it's something that lawmakers and courts around the world are having to grapple with as they try to, you know, adapt these laws to this globalized digital economy.
It's a game of cat and mouse.
It really is. Going back to technical standards for a second, Kochhar also points out this fascinating paradox.
Oh, I love a paradox.
Right.
What is it?
That arises when companies are trying to decide, do we participate in these standardization efforts?
Okay.
So on one hand, they're fiercely protective of their own innovations.
Yeah.
Right? They want to maintain that competitive edge.
Of course. So they're hesitant to share their tech,
Yeah.
participate in anything that might benefit their rivals.
Right. Why give away your secret sauce?
Exactly. But here's the other side of it.
Okay.
If they refuse to play ball
Yeah.
and their technology doesn't become the industry standard, they risk being left behind.
So it's collaborate or die, basically.
Yeah.
Okay.
So if their technology is not compatible with the prevailing standards, it might just become obsolete
Right. Or just hard to sell.
or hard to sell. Exactly.
Yeah.
So they have to kind of weigh the benefits, right,
Yeah.
of staying in control.
Yeah. It's that tightrope walk.
Exactly.
Control versus collaboration.
Yeah. And he emphasizes that, this decision to participate in standardization really often comes down to this strategic calculation of those risks and rewards.
It's high stakes.
It
is.
Yeah.
Okay. So is there anything else you want to point out from the paper?
Yeah. There's one last point that I think is absolutely crucial,
Okay.
especially in this fast-paced tech environment. Kochhar really stresses the importance of what he calls tacit knowledge
Okay.
in building a truly effective IP strategy.
Tacit knowledge. What's that again?
So tacit knowledge is the kind of knowledge that you can't write down.
Okay.
You can't codify it.
Okay.
It's really that accumulated know-how, the experience, the intuition that comes from working in a field for years.
So it's like the art behind the science, right?
Exactly.
Like you can't get that from a book.
You can't get it from a textbook.
Okay.
You can't get it from a patent application.
Okay.
And he argues that this tacit knowledge is often what sets companies apart,
Yeah.
in the tech industry.
Right. Because you can't copy it. You can't reverse engineer it.
Exactly. It's their secret weapon in many ways.
Yeah.
And he says that, companies need to find ways to capture that knowledge,
All right.
to leverage it, whether it's through training programs, mentoring, or even strategic partnerships.
So you create this culture of learning,
Exactly.
sharing within the company.
Because otherwise, that valuable knowledge walks out the door when an employee leaves.
Right.
And it's something that I think a lot of companies overlook.
Right. They're so focused on the patents and all that.
Exactly. Building those legal walls
Yeah.
around their IP.
It's more than that.
It's more than that.
Yeah. Really important point. I think we've wrung every drop
Yeah,
out of this paper.
I think so.
Any final thoughts before we wrap up?
Just this.
Okay.
As you explore the world of tech and innovation, just remember that legal landscape, it's always changing.
Right.
What works today might be totally outdated tomorrow.
Yeah.
New laws,
Mhm.
court decisions, technology itself is always evolving.
So you've got to stay agile,
Right.
stay informed,
Yeah,
keep learning.
exactly. And never underestimate the power of a good legal strategy.
Yeah.
In the tech world, it can be the difference between, making it and breaking it.
Absolutely. Well said. That's a perfect note to end on. Thanks for joining us for this deep dive into, the legal strategy of tech.
It was my pleasure.
We'll see you next time for another exploration of the cutting edge.